tuned, and again you're watching Good Morning Nigeria live on the network service of the NTA. Now, before we continue our conversation on the fifth alteration of the 1999 Constitution, let's listen into Ekene Dulue's a compilation of excerpts from yesterday's discussion.
The Constitution provides that you need the concurrence of 24 houses of assembly. That's 2/3 of the houses of assembly in respect of every bill for constitutional alteration that is passed by the National Assembly. And so 44 were transmitted to the state houses of assembly. Now, 35 are the ones that received the necessary concurrence. That means that we still have a number of bills that are still pending at the level of the state houses of assembly. Now, out of the 35 that came back, Mr. President ascended to 16. So 19, Mr. President essentially vetoed.
I think what the President has done is a progressive approach to good governance. By assenting to these 16 bills, especially as it relates to having financial autonomy to the state houses of assembly. But however, we still have some issues to contend with, even with the autonomy being granted the state assembly. What do I mean? The quality of those at the various state house assembly matters in implementing our laws, and that is one of the biggest challenges that I believe that we'll be facing with this authorization that has been given the state assembly in the area of financial autonomy.
I would not say that some of these approvals are sent by the president will be interpreted or translates to devolution of powers, the much sought about devolution of powers, or maybe the elevation of the federal structural arrangement that should be under the system of federalism, but it has its functional implications, I know. There's still very much need to unbundle the national, or rather unbundle the National Assembly of all the lists included in the exclusive legislative list, and this is one good attempt, but it's not very, very much.
All right, I appreciate Ekene Dulue for the compilation of those excerpts. Joining us in the studio here to continue our conversation today on same fifth alteration of the 1999 Constitution, I have the former Speaker of Taraba State House of Assembly, Right Honorable Habu Ajia. Thank you very much for joining us.
My pleasure.
And also here in the studio is former spokesperson, Nigerian Correctional Service, Francis Anobore. He was also Controller of Corrections, a retired Controller of Corrections, and we're glad to have you with us again.
Thank you very much. It's always my pleasure.
All right, and joining us via Zoom is the founder and executive director of the Prisoners Rehabilitation and Welfare Action Power, Dr. Uju Agomo. Dr. Agomo, we're glad to have you this morning.
Thank you very much. I'm glad to be here. Thank you.
Okay, we're supposed to be joined from Lagos. If our Lagos Network Center is ready, then of course we'll go over there. Our guest from Lagos, once it's started, I will be discussing the power sector and the new reforms that will emanate from the amendment to the Constitution. Well, let's begin today by taking a look at one is the renaming of the correctional services as now part of the Constitution rather than prisons. I know there was an act that was passed in that respect, but that also does it. But there's been also a shift. In other words, that the prisons, as it was formerly known, is now moved to the concurrent list. Beginning with Francis Enabore, retired Controller of Corrections. What does this mean?
Well, thank you very much. To start with, the 2019 Nigerian Correctional Service Act changed the name from prisons to corrections with a lot of positive outlook to address long-standing issues. The name change did not just stop there. It came with a lot of reforms to address issues that have been lingering, notably the endless detention of people to await trial, the inability to have a coordinated reformation and rehabilitation program, the need to address the overbearing population of those that are awaiting trial, the need to address the issues of surrounding taking every little infraction to prison, that is giving prison sentences to every little infraction. So all these things were put together that informed the name change. But now we are having a complete shift. That is the 1999 Constitution Alteration number 15, which is now surrounding the issues of migrating the Nigerian Correctional Service, as it were, from the exclusive list to concurrent list. To be candid, I don't, as far as I'm concerned, I don't really care wherever the institution is domiciled. But if you ask of my opinion, I will tell you that every policy shift is naturally designed to address identified problem. The question we ask ourselves is, how will the migration of Nigerian Correctional Service from exclusively to concurrent list address the problem of overcrowding? Because we have, over time, this particular issue has been singled out as the major problem that confronts the Nigerian Correctional Service in all its deliveries. Are you talking about rehabilitation and the reformation of inmates? Overcrowding will not allow it to function. In fact, it makes travesty of all efforts to work in that direction. Are you talking about agitation, or whether you call it prison evasion or escape or attack or riot? Everything is traceable to overcrowding. I'll give you a typical example. In South Africa, for instance, the population of inmates there that are awaiting a trial is about 33%. In Egypt, it's about 34. In US, it's about 23. Here in Nigeria, it's 70. In fact, it oscillates between 70 and 75%. Another country that runs along this same trajectory is Democratic Republic of Congo, that has their population 75% awaiting trial. Look at what is happening to the two institutions. The high level of escape, of attack, of unrest. So I would have expected that much energy and resources, time, would have been deployed to making the Nigerian Correctional Service Act 2019 functional, work. A component of it, which is the non-custodial component, that would have addressed, or that is meant to address, the issue of not sending every little offender to the prison, since 2019 has not been funded with a dime. Right. So how do we progress?
Yes, thank you, Mr. Onabore. Thank you for your opening remarks. I just like to, I know before we started, I asked the question, Right Honorable Ajia, I asked a question to which, we talked. I said, what is in a name? And that question was actually a question that was asked in Shakespeare, Romeo and Juliet, Ordinarily, according to Shakespeare, it's just a way of differentiating, things from themselves. But on its own, it has no content. It has it doesn't impact really, Anyway, if we look at it from that way, I'm asking, what's in a name change? In other climes, we still hear criminals being put behind bars in prison cells, while you have correctional centers, meant for, those with lesser crimes that, you want to really rehabilitate and integrate into the society. What are your views, first of all, on the name change?
Well, to me, honestly, the word prison service, as it were, is just like convicts, where convicts are kept for them to serve their jail terms and be released into the society. But when you say correctional services, it means no matter the degree of your offense, if you are taken to prison, if you are taken to court and you are convicted, you are supposed to go under your terms, prison terms, and be rehabilitated so that you will come back a good person to be taken back into the society. Not just for you people to go there, whether if you, and they kept you there for 2-3 years, then without learning anything, then they now release you back. One. Secondly, there are minor offenders or first-time offenders that if they are convicted, they will not just go and mix up with hardened criminals without rehabilitation, without acquiring skills. Then by the time they are released, they come back hardened criminals. So the word correctional to me is better, much better than just imprisonment.
What I'm saying is that how does that touch, the lives of the people behind bars? The fact that you have changed the name, does it improve the lot of those that you have put behind bars?
It's supposed to come with a lot of investment, a lot of effort, like it was before, where you just kept them and just be feeding them. But if you are told that you are going for correctional terms, then you know that you are going there emotionally. Emotionally, it will give you a sense that you are coming there to be rehabilitated, to change, not just to come and be punished.
Okay, Right Honorable Ajia, thank you very much for the points that you have raised. But we understand that our guest in Lagos is now ready. Of course, it's a regular on Good Morning Nigeria. Odio Omofoma, we're glad to have you this morning. He's the lead power consultant to the Nigeria Governors Forum. Of course, an expert on electricity matters. Odio, good morning and welcome to our program today.
Good morning, Nigeria. Good morning, Kingsley. Thank you for having me on your program.
We'll keep you on hold in the meantime and then return to Dr. Uju Agomo, who is of Power, and we're still discussing the issues of prisons. And let's also be clear about this. The name change of prisons was effected with the passage of the Nigerian Correctional Services Act in 2019. And so part of what this amendment has done has been to insert that name change earlier achieved by an act into the Constitution. But the significant thing is to shift the item on prisons or correctional services as now known from the exclusive legislative list, in other words, where the federal government only had superintendents over the matter, to the concurrent list, in which case both the federal and state governments could have authority to deal with such issues. And many would say that this is a shift that has many ramifications and implications. Dr. Agomo, what are your thoughts?
It's correct. The issue about the implications, it's real, and it's important that we're able to see it and we're able to understand the benefits that this can actually accrue to us, and therefore make sure that we take the right decision in terms of the model that we would like to see. I was happy to hear the discussion around the name change. It's always important that when we look at the issue of corrections, that we go back to our minds in terms of what the Nigerian Correctional Service Act of 2019 clearly stated in terms of the objectives concerning, where you see in section 2, subsection 1, A to D. And I think once you look at what those things are and what is it, the first being that we want the Nigerian Correctional Service to promote international human rights as well as good correctional practices. The second, to promote effective implementation of non-custodial measures by providing the enabling platform for it. And of course, the third about reformation, rehabilitation, and reintegration. And the fourth, really dealing with the issue of controlling the number of persons who are awaiting trial through a very structured and sustainable manner. Now, when you talk about the Nigerian Correctional Service now being placed on the concurrent list, it's clearly a move to ensure that we begin to operate in the spirit of federalism. But there are models. So, for example, if you look at the model in the US, where you have all offenders that are state offenders being administered and treated in facilities that are state prisons. That means the state will completely fund everything about the facility, and all the inmates, which used to be the bulk of the inmates, will be there. Whereas the federal prisons will keep only those who are there for federal offenses. In Australia, is a completely different ballgame. In Australia, what happens is that it is the states that keep all the inmates, including the inmates that are federal. There have been attempts for the federal to set up what they call the Commonwealth of Australia to set up correctional centers for each of offenders, but because they are very few, they rather leave them in the state facilities. But sometimes the state that can't fund will apply for grants from the Commonwealth. India model is completely different, which is where they have the facility, but there is some activities that are covered by the state and some that are covered from the federal level. So the question, therefore, is that given the context of Nigeria, what will serve us more? What would be the best? So if you think about the issue of the structure, the facilities, the correctional service have over 240,000 facilities across the country. They have a lot of staff that have been trained. So the question, therefore, is what model do we have? Are you going to say that all the state offenders, which is the bulk of the inmates in Nigeria, should therefore be on only the facilities that are that are administered by states? Or are we going to say, okay, let them do sharing? Maybe the federal will take care of the staffing, whereas the state will contribute or provide for the issue of the feeding and thereabout. So I think what's important is for Nigeria, we must look at the model that works for us. And I think the key thing is to have a transition period and then be able to clearly identify what will work best for us to make it work in a very effective way. But let me just say one thing, which is really important. Part of the reason why we have consistently high number of persons that are in custody, high number of them whose trials have not been concluded, over 70%, high number of them who stay longer period. The reason is that the agency and the level tier of government that determines who comes into custody is not the one feeding. So what this means is that if the states are indeed the ones paying for the feeding, and which we know is quite a lot of money that the government is spending, therefore you will not have minor offenders. You will not have people who don't need to be in custody. And we begin to utilize non-custodial measures more effectively. So these are the key issues. So there are many issues that we need to bring in mind and see what can work. On Friday, we had a training dealing with this issue, and we're raising this, and we decided that every week Thursday we will begin to do this, because in every ramification there are issues. If you talk about rehabilitation, there are issues. Some other argument is that will there be something more in terms of the money going to the states now that you have more roles for the state to play? But I think that there is the golden opportunity for us to improve on what we deliver in terms of corrections. Let's just understand that the reason why people are processed is that we want to make sure that when they come out, for those who have committed offenses, that they will not re-offend again. But you and I know that there are people who are in there that are innocent. You and I know there are people who are there who are minor offenders. We must have a justice system that can work for us. But this is a good step. But as I said, it has to be well structured. But there are other things that need to go along. For instance, do we have state policing? Do we have other factors that will make the complementarity and synergy building more effective? So that's my initial thoughts around this. So it is good, very good, but it has to be fully thought through, processed, and there needs to be, a transition period and some discussion here so that we can so clear, because the models are different. There are different kinds of models in terms of addressing this. So Nigeria must take what suits it best.
Thank you again. Just staying with you. I know that the change in nomenclature, of course, would mean undertaking some reforms that will reflect, the new status of that agency. And some of these reforms would come, by way of constructing maybe new correctional centers. Now, given the shift now from the executive legislative list to the concurrent list, it will mean that states will now undertake these very lofty reforms. Do you think it's too weighty for the states to carry on?
No, I don't think so. But let me just say this so that we also understand. For example, if you look at the Child Rights Act, there are requirements for states to establish remand facilities in the state. And I tell you, many of the states are not doing it. Even those who are doing it are not, doing the right thing. They are not making sure that that facility is addressing the issues correctly and having the right staffing, the right programming for the young people, So even as it stands now, there's something that the states could do and should do, but they're not doing it. Secondly, when you look at the wordings of the Nigerian Correctional Service Act of 2019, you will see there are still openings that welcome state participation. Take, for example, the issue of community corrections. Very few states that you see that have made an attempt to provide some support to the Nigerian Correctional Service Non-Custodial Directorate. For example, and I must say, Kwara have been able to provide facilities and encourage some establishment of the correctional non-custodial centers in some of their local governments. So it is important. The other day I was at Kuje and I saw that what the area council is also doing there in support, but many more should get involved. So again, you talk about the issue about rehabilitation. So let's look at it very clearly. First, there is no need to build more facilities. Why? You have over 240 something facilities and that we don't need it all. But the problem is that the ones that are there, we have not done the right thing. So if you look at the Nigerian Correctional Service Act of 2019, it clearly says the issue of ensuring the proper equipping, security, gadgets, CCTV cameras and all that are put in place. Nobody has funded the correctional service to do that. So why not we think of this issue? How can the state begin to engage with the correctional service? For example, if the state wants to now use the facilities that are already there, all of the states, all of the states of this country do have facilities that are for correctional issues, custodial centers. The last that was constructed was Bayelsa. It is only we have Bayelsa, one in Bayelsa, we have one in Ekiti. But if you look at section 34 and 35 of the Nigerian Correctional Service Act of 2019, you will see it's saying that we should have female facilities, at least one, in each state of the federation. Separate facilities. It's talking about having separate facilities for young offenders in each of the states of the federation. So the state can come in to provide support. What of the area about the rehabilitation? So I think there are some very creative things that even without anything that the state can engage in. What normally happens is that many times the state will say they won't do it, that the Nigerian Correctional Service is a federal institution. But what they fail to realize is that over 80% of those who are in those custodies are people who live and operate from that particular state. Perhaps a state like Akwa Ibom, I think perhaps Akwa Ibom is the only one that comes to my mind easily, built a facility for Nigerian Correctional Service. But there needs to be more engagement and more support.
Dr. Uju-Agoma, we're having to let's pause you in the meantime. We will return to you in the course of the conversation. But since we're still riding on the correctional services, I want to crave the indulgence of Odion Omofoma in our Lagos Network studios for me to pop one last question, at least in this segment, to Francis Enabure, who's a retired controller of corrections, or controller of prisons, as the saying used to be. Part of the argument you made a while ago was that, what was needed would have been to boost the capacity and also further enhance the budget, if you may, of the correctional services, to take a look at all of that, including other things that needed to be done. But would that have been a realistic option against the backdrop of the rationale for the movement. It's not just, I want to say this again, not just a name change. That name change was achieved 4 years ago. To say states now could have their own prison facilities or their own correctional services facility. Against the backdrop of the following. One, our population is over 200 million, according to some estimates. Two, we have 36 states in the Federation, plus the Federal Capital Territory. And each of the 36 states of the Federation has its own legislature, and the former Speaker of the Taraba House of Assembly is here with us. They make laws. Local governments also make bylaws. And some of these laws have penalty clauses, and those penalty clauses could be a fine, or it could be an imprisonment, or both. And these are state offenses. And as you said, most of the inmates awaiting trial or otherwise are persons who have committed state offenses. Your prisoner population are those that will be catered for well, until this amendment to the Constitution from the federal purse. And in the meantime, states were creating laws and creating offenses and, of course, a requirement for sentencing and imprisonment, if need be, without recourse to the capacity to be able to engage in corrections. If we took a look at some of these developments that we have seen over the last decades, is the necessity for having the states also to run their own correctional services not so obvious?
Yeah, thank you very much. And I will react this way. Firstly, the issue we are discussing is how to make an institution functional. How to, if perhaps we're seeing a situation where we are counting the number of ex-convicts that are doing very well in the society, that have some of the trades they learned while they were in incarceration, they are leaning on it, they are even using it to shore up the economy of their immediate community and Nigeria as a whole. Probably we won't be talking about whether to retain correctional service in exclusive or whether we are to migrate. The problem we are faced with is the seemingly dysfunctional system that now transcends to a high level of recidivism, that repeat offending of ex-convicts. That's why we are in this situation that we are now trying to discuss whether it should migrate or not. Well, we are where we are. And like I said from the beginning, I'm not bothered, as far as I'm concerned, wherever is domiciled, provided we have a functional system. And I ask you a question. If we have state chief executives that will respond, quickly to issues of trying those that are in custody, awaiting trial, converting this large army of persons behind bar from 70% awaiting trial to 70% convicts, the system will be able to deploy them to functional engagement. We have the Nigerian Correctional Service has close to 20 agri projects, including large-scale farm centers all over the country. Some of them can't lock more than 30% of their installed capacity because there are no convicted inmates to work there. So, and like you rightly said, most of these people committed state offenses, and it will require the instrumentality of state judiciary to process them. You don't expect the federal body to come and try them. Now, I ask another question. Migrating the Nigerian Correctional Service from exclusive to legislative, how will that translate to employing more judges? Will it translate to capacitating the criminal justice system to be more functional? Where it is now, what is stopping state chief executive that created those laws, those bylaws from local government from creating the same from creating relevant mechanism to address the number of offenders that the laws they created will harvest?
I think Francis Nabori, retired controller, there's a fait accompli here. Namely, the amendment to the Constitution has been passed. So we now have correctional services on the concurrent list. That is what we'll have to deal with. Some of the points you have raised are relevant. They are relevant, but what we are saying is that now you have moved it from the exclusive to the concurrent. So let each state, look, we have instances where persons commit offenses and they are moved from the state, from the locus of the offense. Once there's an imprisonment term, you send them to Gashua, send them to wherever you want to send them to. But now, if you commit an offense in Lagos or you commit an offense in Edo, and Edo has its own correctional facility, unless it has an agreement with a sister state, say Delta or Bayelsa or otherwise, the inmates will join other inmates who are there. Because nobody's going to bear the burden of your keeping that inmate, rehabilitating that inmate, and so on and so forth.
You know, Francis, just hold on, Francis, just hold on. Let's, the Honourable Speaker, I'd like you to come in here. First, again, look at the point is coming from, although, like Inslee said, I mean, it's done. There's nothing much more we can do. But we're looking at how it can be, you know, implemented. But he has made a point. But even now, even when it was, now that it's been on the, you know, exclusive list, there is a lot of, you know, I mean, dysfunctioning. The center has a lot of issues to deal with. Now you shift it to the, you know, concurrent list. I'd like you to speak to it based on economies of scale. What, I mean, how feasible is that? And then secondly, this is supposed to be a deterrent tool in terms of, you know, curbing crimes and all that. How might that work as a deterrent tool?
I have issues with this movement anyway, but then it has happened. Can state government, can they afford to maintain, to establish and maintain correctional centers? It's very difficult. Even cases where there's a collaboration between the federal government and the state, like primary board, where the federal government will bring in maybe 70% and the state government will counterfund 30%. Some states cannot even provide their counterpart fund to assess the funds to work on the schools that are domiciled in their states. And the
deplorable state.
And you can go around and see how our primary schools are.
Yeah, that's because it's not the priority of those governments.
That is it. So
how then do you make it the priority of the governments? So
this correctional centers movement, the correctional services movement from the exclusive to concurrent is going to be very, very difficult for most of the states because it is not their priority.
It's not their priority.
It's not their priority, that's the truth.
And then as a deterrent too.
And yeah, it's a problem.
Well, thanks, Ajia. Well, I don't know when you say it's not a priority. There will be no compulsion almost immediately for you to have your own correctional centers. And just as you are taking up some of the items to say under UBEC, that's Universal Basic Education, states are supposed to provide their contact. For many years, not many states were keen into that. Others would, we were told, rig up figures about and then attract the counterpart funding from the federal government and then use the money for other purposes. It has to do with priority. I mean, we have state governments are busy chartering private jets to go to all kinds of places. So if that, how can that not be a priority? And I think that when we talk about good governance, these are some of the issues to highlight. Nobody is saying that go and build correctional services like you are building low-cost housing. It is to say keep away elements of society who should be in that center for a certain period of time. And when you need them back into society, you bring them reformed. Not that that would be their permanent abode, unless a person is on death row, in which case he walks from that place to the gallows. Let's pause on these prisons issues on correctional services and go over now to Odion Mofoma. Odion Mofoma, again, one of the highlights of the constitutional amendment is the shift from the exclusive list to the concurrent list for generation, transmission, and distribution. I mean, one question to ask is this the end or the death knell for the national grid? And what would that mean?
Okay, thank you, Kingsley. Let me quickly make a correction. Unlike the prisons and railway amendments in the Constitution that moved it from the exclusive list to the concurrent legislative list, the power sector, the electricity has always been a concurrent matter and has always been in the concurrent legislative list in the 1999 Constitution. A lot of people always have always assumed that it was on the exclusive list. No, it has always been on the concurrent list. And what the constitutional amendment or alteration, I don't want to go into that debate, simply did was to amend section 14B and take out a particular word that sort of now changed the interpretation of that section of the Constitution. So if you go to section, electricity is listed in 13, 14, and 15 of the concurrent legislative list. Now, section 13 gives the National Assembly the powers to make laws for electricity generation, transmission, and then electricity distribution in parts that are within Nigeria and partly outside Nigeria, while section 14 gave state houses of assembly the powers to make laws for electricity within their states, covering generation, transmission, and distribution of electricity. Now, the amendment, there was a particular clause that pretty much restricted the rights of states to distribute electricity within their states, and it restricted states to electricity distribution in areas not covered by the national grid. So that was the lacuna that states faced. And if you remember, in 1999, the president-elect, who was then the executive governor of Lagos State, had come in with the ENRO badge. I think it was a 120 megawatt power badge. And his idea was, riding on the back of the Constitution, or his own interpretation of the Constitution at that time, bringing the badge will provide electricity to Lagos State, and pretty much Lagos State will transmit and distribute the electricity within Lagos State. This was as far back as in 1999. Unfortunately, the federal government looked at it, interpreted that section of the Constitution to say, look, Lagos State is already covered by the national grid, so guess what, whatever you can generate, so you bring the badge, but you have to give the power to the electricity you generate to us, and then we will distribute as we see fit. That was then under NEPA, before you then had the Electricity Power Sector Reform Act, or rather Electric Power Sector Reform Act, which further strengthened the federal government's hold over the distribution sector in the electricity market. Having said that, what the amendment has now done is to remove that constraint by states. So states can obviously generate, they can set up their transmission infrastructure within their states, and then they can distribute the power, or the electricity within their states. What is not envisaged is that for states to go into cross trading of electricity amongst other states. So anything that is done within the state's generation, transmission, and distribution has to be within the state's territories, and the states should have full rights over that. Now, does it mean the death of the national grid? Well, this is still evolving because the Constitution has now cleared it, but we now need to make the framework laws. For instance, the existing law in the power sector is the Electric Power Sector Reform Act, and that act gave powers to the federal government through NERC to regulate the electricity sector. He actually set up a single electricity market across the 36 states and the FCT. With this amendment, we expect that state houses of assemblies will go into the business of now making laws for electricity within their states, and that will mean setting up their state electricity regulatory commissions or agencies or whatever authority or name they choose to call it, creating state electricity markets that would also compete with a federal electricity market now, and then also having, generally states will control electricity matters within their states, but it's not as clear-cut as we say it, because we still then need to dimension the relationship between what the federal government can oversee in the power sector, and then what the states can also oversee. In other words, where are the boundaries? What's the interplay between the federal electricity market and the state electricity markets? So I think it's still there needs to be a framework approach to this, so that we do not stifle investment in the power sector, we do not over-regulate the power sector, and we do not further confuse investors who have decided to invest in the sector.
Okay, so how easy might you think this will be? Because obviously, you know, some states will quickly latch on this provision now. But from the hindsight of what happened between, you know, the federal government and, of course, the privatization of, you know, that sector, we know the web, you know, that both parties were caught in. How easy do you think that state governments might be able to wade through these you know, complexities of you know, power generation and distribution as well?
Well, for some states already have a head start. For instance, Lagos State, Ondo State, Edo State, where the state houses of assemblies in these states have been proactive enough to pass some form of electricity laws. But a lot of states won't be ready, and it's naturally so, because you would find out that not all states have equal capabilities to develop laws for their sector. Beyond that, there's also, electricity is a highly regulated industry, and you need to build significant competence. So, first of all, everything will devolve from how the national electricity framework is designed with this amendment, right? And that will set the tone for what the states can do, what the federal government can do in terms of regulations. Everything is about regulations, and then once you regulate, then creating the market, the interplay between the states and the federal. A lot of states won't be ready from day one. We would see some form of transitioning over time. But for the states that are already willing to bite the bullet, it is now important that we come up with a structure. And I sort of have put up I don't know if your cameraman can pan through it, how we, in the Nigerian Governors Forum, how we view the evolving market. We see two types of market evolving: the federal electricity market, which is pretty much the national grid, and then you then have the state electricity markets. This is like the Indian model, where the federal government can make regulations and control generation, transmission, and some elements of distribution. And at the state level, distribution is regulated by the states. So we expect to have an interplay where states set up their electricity regulatory commissions. We expect that the states would have framework that would make sure that the commissions are robust enough to regulate the electricity market within the states. In other words, the licensing, the tariff setting, ensuring that customers get electricity, making sure that private investments come into the sector, right, within the state. Then we expect that NERC, as is currently set up, would also have that interface to say, look, electricity distribution between Edo State and Delta State, the boundary communities, how do we manage it? Who regulates that interface, right? So states would have to develop capacity, but some states have already started that journey, and we expect that more states would come on board. At the Nigerian Governors Forum, we are now working towards developing template laws, template documentation, and obviously would facilitate a number of trainings and capacity development for states who are willing and interested in developing their own electricity markets within the states. But however, where states are not willing, we also envisage that NERC will continue to regulate the electricity markets within that state until when they develop such capacities.
Odion, thank you very much for your explanation, but I still want to stay with you, because there are, as you said, matters that would need to be straightened out in the days and weeks and months ahead. I'm sure a number of experts now will be indicating them just how to deal with the new amendments. But how does this amendment help in resolving the dilemmas that a number of state governments faced. A number of states had tried to have their own power generation, either the installation of gas turbines and so on and so forth. And their complaint was that, look, they generate the electricity and then they are compelled to wheel it out through the national grid. And the percentage that comes to them for distribution, of course, is usually very paltry. So how does this solve that issue? And secondly, you mentioned some states that already have a head start: Lagos, Edo, and I think Ondo. Edo from Ologbo. I've seen somewhere in the capital city, they having their own distribution poles and cables alongside the ones that I think BEDC also has. It looks a bit chaotic, but how does this go side by side with the new deal that the amendment is supposed to offer?
To your first question, a number of states, take for instance Rivers State or Akwa Ibom State with the Ibom Power, they'd gone ahead to build power plants. The idea was they would invest in the power plants and then their city, and that the electricity generated would go to their citizens within the states. But because of the former interpretation of the section 13B of the Constitution, what that meant was that they had to give the power or sell the power or distribute the power to the national grid, and then the national grid will decide where that power goes to, and then the states, the citizens of the states didn't really have the power, electricity. What this will now solve is that a state like Akwa Ibom can now decide, all right, I do not need to wheel the power from Ibom Power through TCN. I will now undertake to build my own transmission corridor that will take all the power from Ibom Power, or maybe some of the power from Ibom, from the generation plant, bring it to the state capital or wherever it chooses to go, and then they may also choose to license their own state distribution entity that will then take that power. Remember, the power, electricity is a chain. You can't break it. You have to generate it, you have to transmit it, and then there has to be an end user that will consume the power. What the states faced was that end user part of it, they were not allowed to sell power to that end user. It was only the federal government that could determine who the end user was. In this instance now, the chain, the value chain is now complete for the states. They can then determine on their own who the end user of that electricity will be. And in determining so, they would then have to build the necessary infrastructure or attract the right investments and investors to build the necessary infrastructure that would then take power from wherever it's generated within the state and take it to wherever the end user is also within the state. So hopefully that will solve some of the complaints that states have been faced with, because at the end of the day, successor distribution companies managed by NERC, which were privatized, were subject to whatever power they receive from the national grid. Even though, take for instance Benin has 2 power plants sitting there, almost 1,000 megawatts, yet Benin is in darkness because BEDC will tell you it is whatever we receive from the national grid that we're able to distribute. In this instance, Edo State has licensed Osioma Power, and Osioma Power can now go ahead to get a distribution license from the state, assuming the state then creates its own state regulator that would issue that license. Osioma Power can then decide to now start to build a transmission line that will take power to wherever Edo State government or wherever it chooses to take the power to, not only in rural areas. That's one bit of it. The other bit is from an investment perspective. A lot of people have said states may not be viable enough to invest. We do not expect state governments to make the investments themselves. We expect that whatever laws that the House of Assemblies will pass in electricity would be sufficiently robust enough to attract private sector investments to build the electricity framework and market within their states, right? Because this is flowing from what the former Speaker of Taraba was saying about the prisons. In other words, the state's ability to build correctional centers. Let's take that conversation into the power sector. I do not expect that states will then go ahead to start to build build power plants, or start to invest in transmission networks within their states, or then license a state distribution company, and then they would have to put state resources to funding it. I expect that whatever regulations are made should be robust enough to attract investments at state level within these various sectors of the state electricity markets. That is exactly what will drive it. But if we're waiting for states to put their own money, maybe part of their internally generated revenues or whatever they get from the federal government, into building these entities, I think we may not go too far. So what I would really urge the states and the houses of assemblies within the states to do is make the laws and make sure that the laws are robust enough that would attract investment within the markets within the states.
Thank you. I just one more before we let you go and come back to the studio. And I'm glad you talked about the part or the role of the investors. I know for the investors, I mean, the investors will probably be jubilating right now, you know, and all that. But what will be of concern is to the consumer. I'm wondering how this will resolve the, again, dilemma of, you know, supply, dilemma of sustainability of supply. How will it resolve or provide electricity for my mother in the remote village of Umpam in Imo State, or my mother in Okapume in Ilorin, or the one in Otigboti in Bayelsa? Does it?
All these names, where are you getting them from?
You know, so you know, and again, how will it address the issue of billing, which is another you know, problem that may arise? You know, problem that may arise.
All right. Immediate impact is not. There will be no immediate impact yet until Imo State House of Assembly makes a law that says we will now allow maybe a private entity to go generate and distribute electricity in your mom's village in Imo State. Right, without those laws being made, it's going to be hard. But here's what it gives to long-suffering electricity customers. What it has now done is to create a competitive framework. In other words, we're being served by 11 successor electricity distribution companies, which we commonly known as we call them discos. Now, we do not have an opportunity to migrate. So, in other words, if Ikeja electricity is not providing quality service, I do not have an alternative other than my generator. What consumers now have with this arrangement is that once Lagos State decides to license third parties or to create distribution frameworks or distribution networks, I then have an opportunity as a consumer to either stay with my current supplier or move to another supplier. Another school of thought is what the states might do is to say, look, Ikeja Disco, make your lines open. In other words, anybody can generate power and put into your network, and then I can get power, because Ikeja Disco would always tell you they do not generate electricity. So what the state can then do is to say, look, we have somebody who will generate electricity in Oregon, but you must open your network such that the person can put the electricity in your network, and then somebody down Alausa will get the power, or somewhere in Ogba or some village will get it, right? So what this creates, again, subject to the quality of the laws that the state houses of assemblies will pass. Again, I need to re-emphasize that everything is dependent on the quality of the laws that the state houses of assemblies will pass. Once that is, if that is done very well, I expect in no time that people in remote areas, communities would have an alternative, because you would then have the state laws mandating certain parties to go set up electricity franchises in those areas. Those of us in the urban areas that are already covered by the national grid may be lucky to have generator companies who would provide more reliable power other than what the discos get from the grid. Or we might even have a completely different network like what we're having in Benin, in Benin City, where OCM is actually building a distribution, well, in collaboration with the state government, is building a distribution ring. So we now have businesses, individuals, hotels, commercial entities who actually have a choice of staying on the existing network or paying a connection fee and joining the OCM distribution network, where they have almost 99% availability, right? They may pay, I don't even think they pay higher. The cost is almost comparative. Somebody has argued that, well, I've heard arguments that this creates, this increases the cost in the sector. Imagine thinking about having multiple regulatory institutions at federal and state. You have an increased regulatory cost and other costs as well. My take is, look, the cost of darkness is far too much. Just last quarter alone, Nigerians spent over 800 billion billion naira to buy diesel. Meanwhile, what the National Grid got as tariff was less than 200 billion. So Nigerians are paying far more for darkness. So if there's an increased cost in making sure that we now have more power on the grid, right, and then we pay less, I think it would reduce the cost. Where we don't have to then queue up for petrol or diesel to fuel our generators, or where we're not spending so much money to now buy solar panels that will only give us electricity that we can use to power our fans or TVs without, and we're afraid to turn on our ACs. So from a cost perspective, I think, yes, it might increase the regulatory cost and other costs as well, but in the scheme of things, we're already paying far too much for darkness, and I think it's a welcome development. But states need to move fast, get the right laws within their framework and within their states, and then activate private investors that will start to make these franchises.
All right, Odio Amofoma, thank you very much there for your contributions. We're going to have a short break now. When we return, we'll continue with the conversation.
Okay, I learned about the Jeep loan through Mrs. Umar, who is the desk officer in Calabar South of the National Orientation Agency. I registered through her. Thereafter, I was shortlisted. At first, when I heard about the program, I didn't believe it. I was thinking it was a scam, because you've been hearing a thing of this and it's been so rampant everywhere. But I was optimistic that it will come to reality. Before now, I was unable to own a stand. Before now, I was able to get few important ones, and that's been helping me to work, and at the same time make me own a stand where accessories are being sold. So I thank the federal government for the program.
Every day in our country, senior citizens are discriminated against, disparaged, and treated with disdain by those who ought to respect them. We are all complicit in the way we have treated the elderly members of our society as institutions, families, or members of a shared society. Every time senior citizens get offered less than they deserve for the work they do because they are old, poor, and desperate, we are failing them. Senior citizen loses a child, and wow, they must be responsible for their death. Every time a senior citizen gets labeled a witch, is called mad, and shooed out of the way because they have no memory of where they were headed and look unkempt, we are failing them. We say, abeg, you don't old, make it do die, make everybody for rest, to ailing parents, uncles and aunts. That's discrimination. That is neglect. When you see an old woman getting beat up and being accused of witchcraft, do not turn the other way. Stop and teach people that white hairs, wrinkles and hunchbacks are no evidence of witchcraft. Aging comes with a memory decline. Sometimes it's not out of place to have elderly people lose their way, forget details of their lives and how to properly take care of themselves. When they get to this stage, they deserve your empathy, not scorn. Our ailing fathers, mothers, aunties and uncles are deserving of quality healthcare and peaceful transition. Make their last moments memorable. Senior citizens have paid their dues. They deserve your care. Stop all forms of discrimination against them today.
all I need to say about the second River Niger Bridge, 21 years ago, as I came onto this throne, it will normally take you 3 to 4 hours to cross the bridge. I mean, if you are going to Lagos, you spent almost half your time on the bridge. And you were stuck on the bridge before you came across from Asaba this morning. Now, could you imagine how the people of Onitsha and Asaba have endured such a situation for over 25, 30 years? This is reality. We cannot overestimate the importance of the second River Niger Bridge. To express appreciation to our President, Muhammad Buhari, for being the vehicle for the execution of this monumental project.
All right, you're welcome back, and it's still Good Morning Nigeria on network service of the Nigerian Television Authority. Let's return to the conversation on the change of the locus of prisons, correctional services, now to the concurrent list. Dr. Uju Agomo, if you're still there with us via Zoom, I want to come back to you. We do know that there will be a lot of protocols going forward to actualize this. And the former Speaker of the Taraba State House of Assembly has said, look, states do have their own challenges, and I chipped in to say that, look, it's just a question of priorities. If the federal government had been bearing the weight of the number of inmates, whether awaiting trial or convicts or otherwise, and we do know that there are state offenses, but there are also federal offenses. Why can't states at this time begin to think of appropriate investments in that particular sector? And Akwa Ibom, I think somewhere in Ikodekpene, built a prison facility which is handed over to the Nigerian prisons, now the correctional services. So is it a big deal to build a prison, whether it's medium security or maximum security, to, of course, provide a place for rehabilitation or custody for elements who are not immediately wanted in the larger society?
Yeah, thank you very much. I think there are some few things that I really feel that I should indeed provide a little bit more information about. So we're talking about corrections now. Corrections is not only about imprisonment. So when we think about this, let's ask ourselves, what are those openings? So even, I think, even at the local government level, I gave you an example of what some of the support from Kwara towards the non-custodial element, yet different aspects of support to make sure that corrections happen. Everyone you see in custody, one day, unless they are life sentence inmates or on death row, one day they're going to go out into the community. So we must begin to look at corrections in a very holistic level. So when we talk about deterrence, deterrence doesn't mean that you're only deterred when you are in custody. Remember, as I said earlier, there are people there who are innocent, there are people there who are minor offenders, and of course there are those who deserve to be in custody because of the nature of the offenses. So we need to see custody in all its ramifications. There are also disadvantages of that because you are separated from the community and the rest of that. But let's come back to this whole issue. There's nothing wrong in the state getting investment in this process. It makes the states safer. It is also important to note that it had not always been in the exclusive list. There were times where the different regions had different ways of addressing issue regarding custody. It's also important to also let people know there was also a time when we didn't even have prisons for some jurisdiction. There were times where that wasn't the case. But anyway, now we have prisons. It is now important to say we now have it in the concurrent legislative list. What can we do? And my thought is this, because earlier on I said we have over 245 or more custodial centers, including the satellite custodial centers that are currently under the management of the Nigerian Correctional Service. So is it not possible, as part of that, because that's why I talked about the fact we need to look at what is the framework that will work best for us. What is that we need to utilize, given our own peculiarity? Will it be a situation where you will say, okay, there is already structures? Is it possible that these structures will be there? And you will now say these are the aspects of intervention that the state should do? Or could you then say, okay, maybe the federal provides the staffing, but the state will contribute to the issue of the feeding? Or will you now say, okay, the state, if you want the correct federal one to support you, we do this, and these are the terms, this is what you need to bring to bear. Let me also clearly mention that what we must always remember is that there is a chain within the criminal justice system. The main agencies that determine who comes into that process are law enforcement agencies, the policing agencies, and the bulk of them are federal. You see, have the police and the rest of them. And then you get to the issue where you now get to the prosecution. But for example, if it is the Ministry of Justice, you have both state and you have federal. And the bulk of it is done by the states. You come to the judiciary, you have both states and the federal, but the bulk of it is done by the states. So what I think is that we must put incentives. You know why the state does not care much as we see it now? Is because they are not the one paying the cost. If in your house, you are the one feeding everybody that comes to your house, you will determine how many people come to your house. And that is the actual truth. The bulk of the state where you have the highest number of inmates are where? Lagos, Rivers. These are rich states. Okay? But I know that even in Lagos, if they know that they are the ones feeding the inmates, they will not just bring any and anybody in there. So I want us to see correction in a holistic package. I also want us to see the advantage in what has just happened. But these advantages can only be attended to if we look at how the model we will take here will suit us. When I started, I gave the different kinds of models that are out there in the world for countries that have that are running a federal system. So we need to look at that clearly. There's one more point I just don't want us to forget. It's about standards. So you talk about capacity. So even if the states are doing, there's a need for issue about the capacity of the persons that will administer the processes. But it's also about how do you ensure that we have proper benchmarking, performance assessment and tracking, and the whole notion about standards. So will there be a separate national institution that will ensure that these standards are kept, whether they be federal institutions or state? Or will the Nigerian Correctional Service, as it is now at the federal, take that role to play that?
Okay, Dr. Gomo, thank you. Just a last question for you. Just give us a sense of understanding of what should begin to happen right now. I mean, now that it has been moved to the concurrent list, what should begin to happen right now? And what kind of enabling framework would you want to see put in place, to enable implementation of this act?
So the first is to be able to look at what are the critical framework that will work best in Nigeria. And this decision should be made in the next few weeks or month at the very most. We need to understand what model, and I've given those examples. Or if we want a situation where you take the liberty to make that decision, then these three options, the various options have to be out there. And I've given those options, but I think that needs to happen. And linking to that issue is the notion of making sure that we develop the transition framework. What should be the transition? So in this sense, what should happen the next, how many months or how many years do we expect, and what are the options? Thirdly, is to look at how to then develop, whether it's the model laws and model operational guidance that the state can easily adapt, so that you don't have mad processes. And there have been a situation where this has happened in the past. If you remember the Administration of Criminal Justice Act of 2015, many of the states began to adopt it as Administration of Criminal Justice Law of 2015. We need to do the same kind of thing with the Nigerian Correctional Service Act of 2019, and indeed the various standing orders, both that the custodial standing orders and the non-custodial standing orders. Then the states must be intentional, must make allocations available. They must, now there's no way running away from it. The state must fund. So you need to then decide what kind of appropriate funding do you need to put in out there. And I had already said that there are things that can be done in the community. There are, even at the moment, certain of those areas that needs to happen about young offenders for issues, and a lot of young people are out there. So I think it's about looking at the legal framework. It's about adequate budgeting, and when we talk about adequate budgeting, it reminds me of something. The issue about rights funding. Look at, for example, Nigerian Correctional Service, the non-custodial directorate and processes that were developed from the Nigerian Correctional Service Act of 2019, not properly funded. So we shouldn't have that to repeat itself. So it's about the framework. It's about also making clear these operational guidance that should help and guide both the state and the federal. And it's also about determining what should be that agency that we need to regulate in relation to standard setting and benchmarking, so that we don't get ourselves into a big problem. And finally, it's about budget. So I think that once we do this,
Dr. Uju-Agomo, thanks a lot for the points you've raised. We're discussing two issues here relating to the amendment of the Constitution. We started the conversation yesterday. This will be an ongoing thing. What is clear, obviously, would be that going forward, there will be need for investment in infrastructure, investment in personnel, engagement of personnel, training of the personnel, reward of the personnel, and then running of the correctional facilities themselves. But Dr. Uju-Agomo made a point about if people don't care about those, who come to their house to eat because they are not paying the bills, when they begin to pay the bills, obviously they will begin to care. And it just leads me to a point, because we say that, oh, we have, I don't know what number, I mean, I don't remember the number that Dr. Agomo said, correctional facilities. How many of them are modern? Sometimes when they want to complain about jailbreaks, they will tell you, oh, these are mod prisons that were built over 100 years or so ago. We don't expect today, if states are going to invest in infrastructure, that they will be building mod prison walls. So for you, I think this is very important. As a lawmaker, how many times, for instance, did your members say they were going on oversight to the prisons to go and see number of state offenders so as to facilitate or assist?
Well, I cannot think of one. I cannot think of a time where legislators, even when I was in the House Assembly, I've never taken my time to visit the prison, talk less of those that are coming behind me. And for this thing to work at the state level, actually there are gray areas that the federal government and the state government need to iron out and come out with one. Which model are we going to adopt? Secondly, a framework where what role would the federal government play and what role would the state government play? To me, the state government can only come in maybe with infrastructures. But when you try and ask the state government to take care of feeding, there will be problem. There will be problem.
Why would there be problem?
Okay. Because to feed a prison...
You have less than 60 seconds.
To feed a prison per day now, a prisoner is like 700 or 800 naira now. 750.
On paper or in reality?
In reality, that's what the federal government
Have you had the experience of feeding in prison?
Yes, I have. 750 per prison a day.
Per prisoner?
Per prisoner a day. Then times the number of prisoners or inmates, let me use inmates, in that facility. Then times 30. Take Jos. They used to have about 1,100. If you are to feed them 750 a prisoner, then times the number of prisoners and times 30 or 31 days is roughly around a day is 750.
Yeah, I'm sorry to cut you short, but Francis Enabore said that part of the way to do this is to get the state governments to be more proactive and reducing the number of awaiting trial inmates. If a state government knows that it is going to have to spend this much, according to the math that you have been trying to sort out, the state government then will say, so, listen, this is where the problem is coming from in terms of financial outlay. So let's deal with that aspect of having too many awaiting trial inmates, and then the process will be a lot more simpler. But now they don't bear the cost.
The
what
mathematics
happens?
is saying it's not realistic. with the dynamics now.
No. It's not. It's not. Well, what we are saying is, I think I'm just trying to re-emphasize the point that Enabore made earlier. Enabore, I don't know. Sorry, we're juggling. Amafama is still in Lagos. He's still waiting, to hear something. Amafama, very quickly. I know this is a very interesting conversation. It will be ongoing. Usually, when you have a new law, there's a lot of conversation around it, and as you said, this will include the framework and so on and so forth. You touched briefly earlier on states having their own regulatory commissions, but somebody would say, look, the doctrine of covering the field. If you already have a neck, why would you then need to have 36, assuming all 36 states decide to have their own regulatory commissions? Why would you have that? What would be the basis of the interface in getting the markets much more functional? That's one leg. And secondly, if you recall, some years ago, we had you on Good Morning Nigeria, and I raised the issue of the ROEBs that Ugbemudia, as military administrator of the Midwest, brought about. That's the Rural Electricity Board. Isn't just this is a way of, as it were, going back to those good old days and assuming that that model worked, then we probably might not have been undergoing the challenges we'll be having with our power sector. Very quickly.
So to first of all, the regulatory coverage of NERC, the question is, does it really cover, should it cover distribution? Because if you really look at Section 13 very well of the Constitution, it doesn't really give the National Assemblies the powers to make laws for regulating distribution. But Section 14 actually does give those powers to the states. So the first question is, based on this amendment, what will be the next role in regulating electricity within states? Again, that speaks to the whole idea of framework. It's very simple, similar to what we're having a similar conversation with what Dr. Oju was talking about in terms of the prisons. There has to be a framework. What's the framework arrangements in terms of the federal electricity market, state electricity markets, and then we then have to have policies at the state and the federal that will synergize themselves. So we do not have NERC and state regulators now butting heads, or investors having to face different regulatory structures, and then that would increase regulatory risk. I believe that for any state, electricity is a regulated business. So if states want to go into electricity business, they would have to have their own state regulators. Otherwise, they might ask NERC to continue to regulate the electricity markets within the states. Again, that depends on the model we want to run. So everybody needs to sit down together now and create a model, a framework model that will guide both markets playing together. To your
I'm sorry, we're running out of time, really. I would just like to thank you. And Anamore, just 60 seconds contribution from you.
Yeah, thank you very much. I don't want to go into what others have already said. I only have a piece of advice for state chief executives, moving forward. I think what they should do now is to deploy whatever resources they have to first converting the army of awaiting trial to convicts, so that they can deploy them to productive engagement. I said earlier that we have the Nigerian Correctional Service has infrastructure almost everywhere. They have farm centers, they have cottage industries. It's for them to engage the respective state body to know where the strength lies, what they can do. The feeding we are talking about, if we have more of convicts than awaiting trial, they can be deployed to these farm centers, produce much more than what they can consume, and then the others to the economy, and also cottage industries. But you can't do that now under the present arrangement. That majority of them are awaiting trial.
Francis Onobore, thank you very much. Controller of Corrections, retired, and of course a former spokesperson of the Nigerian Correctional Service. Let me also formally appreciate Odion Omofoma, who is the lead power consultant to Nigeria Governors Forum. He joined us from our Lagos Network Center. We'd like to appreciate you, Odion Omofoma. Thank you very much. And from here in the studio, I'd like to really appreciate the former Speaker of Taraba State House of Assembly, Right Honorable Habu Ajia. Thank you very much. All right, let's quickly take a look at sports now.
The
The Africa Cup of Nations Côte d'Ivoire 2023 dates have officially been confirmed by CAF, with the opening match scheduled to take place on Saturday, 13th January 2024 at the Alassane Ouattara Stadium, Ebimpe, Abidjan. The 4-week tournament, pitting Africa's best 24 nations, will officially conclude on 11th February 2024. This will be the 34th edition of the tournament and returns to Côte d'Ivoire for the second time after the first being held there in 1984, where Cameroon emerged as winners for the first time. With the AFCON 2023 qualifiers approaching its business end, the road to Côte d'Ivoire is gradually taking shape as the world gears up for Africa's biggest football spectacle. Following this past weekend's thrilling round of qualifiers, 6 countries secured their place for the competition, joining host Côte d'Ivoire. They are Algeria, Morocco, South Africa, Tunisia, Burkina Faso and African champions Senegal. Meanwhile, England legends Michael Owen and John Terry and Côte d'Ivoire great Yaya Toure have been nominated for the Premier League Hall of Fame Award class of 2023. Owen won the Premier League Golden Boot twice with Liverpool, while Terry won 5 Premier League titles with Chelsea and is the highest scoring defender in the Premier League history. According to PremierLeague.com, they have been nominated alongside Tony Adams, Ashley Cole, Gary Neville, Sol Campbell, Jermaine Defoe, Michael Carrick, Lou Ferdinand, Peter Cech, Rio Ferdinand, Yaya Toure, Andy Cole, Robbie Fowler and Nemanja Vidic. Former Manchester United coach Alex Ferguson and former Arsenal coach Arsene Wenger were announced as inductees on Wednesday, March 29th.
Okay, that's it for us on Good Morning Nigeria today. Thank you for tuning in. We hope you join us on Monday, same time, 7 o'clock in the morning. Enjoy your weekend. But look after yourselves. I'm Kingsley Osadamo.
And I'm Claire Adelabu Abdul Razak from all of us, the GMN team. Have a pleasant weekend. And always remember to join us in our fight against rape and rapists. Bye-bye.